those of you who don't know me, my name is Danal Gopal. I'm an HR consultant here at HR Talk, and I would like to welcome you to today's session on retrenchments in the South African labor law context. Our focus will be on Section 189 of the Labor Relations Act, which governs dismissals based on operational requirements. This is a topic of great importance for HR professionals, line managers, and business leaders, especially in times of economic uncertainty or organizational restructuring. Today, we will explore the legal framework, procedural requirements, and practical considerations involved in managing retrenchments fairly and lawfully. Just in terms of questions, as we get into it, if you guys have any questions, please pop them into the chat and I will get to them at the end of the webinar. Before we begin, I must emphasize that this presentation is intended purely for educational and informational purposes. While every effort has been made to ensure the accuracy of the content, it does not constitute as legal advice based on your specific situation. The application of the labor legislation can vary significantly depending on the specific circumstances of each case. Therefore, I strongly encourage you to consult a qualified practitioner for guidance tailored to your organizational needs if you need advice on retrenchments. In today's session, we will focus on Section 189 of the Labor Relations Act, which deals with retrenchments. This section is critical for understanding how to manage the workforce changes in a legally compliant and ethically responsible manner. Section 189 outlines the processes that must be followed when dismissals are contemplated due to operational requirements. Our learning objectives for this session are threefold. First, we aim to develop a clear understanding of the legal framework provided by Section 189 of the Labor Relations Act. Second, we will examine the procedural steps that employers must follow and the rights of employees or the rights employees are entitled to during a retrenchment process. And third, we will explore the practical considerations and key takeaways that can help ensure compliance and minimize legal risk. The Section 189 governs dismissals that are based on operational requirements. These are dismissals that are not related to conduct or performance of employees, but rather to the needs of the business. Operational requirements may include economic challenges, technological changes, restructuring, or closure of a business or department. It is important to understand that retrenchments should always be considered as a measure of last resort, and employers are legally obligated to explore all reasonable alternatives before proceeding with dismissals. Section 189 requires that any retrenchment process be conducted in a manner that is both procedurally and substantively fair. Procedural fairness refers to the requirement that employers must follow a structured and transparent consultation process. Substantive fairness, on the other hand, means that the reasons for retrenchment must be valid and based on genuine operational needs. Now, when we talk about operational needs or operational requirements, remember it's economic challenges, technological changes, restructuring, or closure of a business or department. Employees who are retrenched are entitled to severance pay, which is typically calculated as 1 week's remuneration for each completed year of continuous service. So it is a completed year of service, then only are they entitled to that 1 week severance pay for each year. In some cases, employers may offer more generous packages, so you can add on ex gratia payments, but this is not a legal requirement. Legally, when we look at pay, it is only 1 week's severance pay for 1 week for every completed year of service. The retrenchment process can be broken down into 5 steps. The first step is to identify and document the operational reasons that justify the need for retrenchment. The second step is to issue a notice or written notice in terms of Section 189 which must be provided to the affected employees or their representatives. This notice must include detailed information such as the reasons for the proposed dismissals, the number of employees likely to be affected, and the proposed selection criteria. The third step is to engage in meaningful consultation, during which the employer and the consulting parties must attempt to reach consensus on measures to avoid dismissals or minimize dismissals. The fourth step involves applying a fair and objective selection criteria to determine which employees may be retrenched. The final step is to communicate the outcome of the process, issue formal notices of termination, and ensure that severance pay and other entitlements are provided to the employees. Employees have several important rights during a retrenchment process. They are entitled to be consulted and to participate in discussions about the proposed dismissals. They have the right to suggest alternatives to retrenchment, such as reduced working hours, maybe being put on short time, voluntary separation or voluntary retrenchment, or redeployment. The selection criteria used to determine who will be retrenched must be fair and objective, and employees must be informed of how these criteria will be applied. So one of the examples is last in, first out. In addition to severance pay, employees are also entitled to any outstanding leave pay and notice pay, if applicable. Employers are also encouraged to consider offering emotional support and career counseling to the affected employees. It is essential that employees understand their rights and responsibilities during the retrenchment process. They should be aware that the process must be conducted fairly and transparently, and they have the right to be consulted and to make representations. They should also understand that the basis on which the selection decisions are made, and they should be informed of any opportunities of alternative employment within the organization. Employees should not hesitate to ask questions or seek clarification during the consultation process, and they should consider seeking advice. They can consider seeking advice from a union representative or a legal advisor if need be. Employers have a legal obligation to ensure that retrenchments are both necessary and fair. Okay, it must be based on operational requirements. They must be able to demonstrate that dismissals are based on genuine operational requirements, and they must engage in a meaningful consultation process with the affected employees or their representatives. The consultation process during retrenchments or during this procedure is very important. Employers must also consider all reasonable alternatives to retrenchment, such as redeployment, job sharing, or temporary layoffs. The selection criteria must be agreed upon with the consulting parties, or if there is no agreement, or if no agreement is reached, must be fair and objective. Employers must also comply with all statutory requirements regarding severance pay, notice periods, and the provision of relevant information. Human resources plays a critical role or a central role in managing the retrenchment process. Before the process begins, HR should assess whether the plan, or HR should assess whether there are any viable alternatives to retrenchment and prepare a detailed consultation plan. This includes identifying the affected employees, drafting the Section 1893 notice, and planning how communication will be handled. During the consultation process, HR must ensure that meetings are conducted respectfully and that employees are given every opportunity to ask questions and make suggestions. After the process is complete, HR should provide support, if applicable or if they can, to the affected employees to ensure all legal requirements have been met and help the organization move forward. There are several common mistakes that employers and HR professionals should avoid during the retrenchment process. One of the most Serious mistakes, the most common problems, is rushing the process or failing to consult properly, which can lead to claims of unfair dismissal. Another mistake is using arbitrary or discriminatory selection criteria. Remember, when we look at selection criteria, it has to be fair and it has to be objective, right? Okay, just hold on. We do have a comment about my slides not being in sync. I just want to check. Just give me one moment. Okay, so I'm assuming everybody can see my slide on what HR should do. We are getting there. I just want to talk about the issues that we commonly face. Okay, so as I was saying, employers must also avoid withholding severance pay unless the employee has refused a reasonable offer of employment. Finally, it is essential to consider redeployment opportunities before proceeding with any retrenchments. To ensure that the retrenchment process is handled effectively, employers should prioritize transparent communication with all stakeholders. It is important to document every step of the process, including consultation meetings, decisions made, and correspondence with employees. Okay, so when we look at what HR should do, when we look at the pre-retrenchment process, planning and consultation, we need to ensure that we've assessed all alternatives that we can provide. So that includes whether it's reducing costs, cutting hours in terms of short time, or reassigning roles instead of retrenching. Because remember, retrenchment is considered as a last resort. Okay, we need to prepare a consultation plan. All right, so we need to identify the effective employees and plan clear communication and consultative procedures. We need to notify the employees in writing. Remember, you issue a formal Section 189 notice detailing the reasons for considering retrenchment or restructuring, the affected position, the proposed selection criteria. You would also have other things in that notice, such as the time frame as to when the notices for dismissal, if that is going to happen, will happen, the time frame for this procedure, how it will unfold, when we propose to consult with them, and all of those important details. During the retrenchment process, we need to ensure that we are holding consultative meetings. So we need to allow the employees to ask as many questions as possible so that they can understand, make suggestions, and discuss any alternatives that they might have thought of that the employer has not considered. All right. Apply a fair selection criteria. So we need to ensure that when we're doing a selection criteria, when we're selecting how we're going to apply, we need to avoid discriminatory selection criteria. We need to ensure that it is objective and transparent. All right. So if you're looking at something like a skills relevancy, you would do something like a skills matrix and then look at the skills that the employees have in order to make your decisions. It must be fair and it must be objective. You would not take into a manager's personal opinion as, okay, this person is late all the time, so we don't know. That does not work like that. When we look at retrenchments, we do not look at the individual people. We look at the positions that is being affected. All right. Then we would offer alternative positions if possible and if feasible. Okay, so only if there are other alternative positions or if there are alternative solutions, we provide redeployment or reskilling opportunities. And lastly, during the process, we provide retrenchment packages and support. So remember, in a retrenchment process, they are entitled to severance pay unless they refuse a reasonable alternative offer of employment. You would provide them with all of their UIF documentation so that they may go and claim UIF. You would pay them out any leave owed at that point in time. And any notice pay, if they are not working the notice period, you would provide them with the notice pay. Okay. When we look at post-retrenchment, we offer emotional and career support. So this is if possible. What you can do is you can do a reference letter for your employees that have been retrenched. You can assist them with job placement and provide counseling. All right. The most important thing in this whole process or within any HR process is to ensure that you are keeping records. Okay. So documentation is vital, just to ensure that you have consulted, that you've done all the necessary steps that you need to do, and it helps you and it protects the employer in terms of any legal disputes that may arise. Okay. Lastly, rebuilding the workplace morale. If there's any concerns afterwards, it is your responsibility, or HR should do best practice, is to try and help refocus the team to restore productivity within the organization. Because retrenchments, remember, retrenchments is considered a no-fault dismissal. So hence, we need to ensure once the process is completed, we try our best to restore productivity within the organization, which sometimes is, as we understand, easier said than done. Okay, so when we're looking at, once again, what employers and HR should not do, remember I spoke about all the mistakes that can happen. Rushing the process is one of them. Remember, employees need time to review the letters that you've given them or the notices of restructuring. They need to consult with their legal representative if they like, or their trade union representative. You need to give them time to do all of this. All right. So you would not have the written notice and then the first consult and the second consult within 3 days. Okay. That doesn't make sense. You need to give them time to process. You need to give them time to think over and identify if there's any alternatives that you may not have thought of. All right. Secondly, select employees arbitrarily. Remember, like I said, it must be based on an objective and fair criteria. All right. You cannot decide that just because this employee performs better, I would like to pick this one. No. When we look at retrenchments, we don't look at individual employees. We don't look at people. We look at positions, right? That's where you start. That's your starting point of being fair and objective, is that you take out the people of it and you look at the positions, right? And you look at, okay, who do I need in terms of restructuring? If we looking at restructuring, or in terms of the department, or whatever the case may be, but you look at the positions that are being affected. Okay. You cannot deny the employees their rights. So they have to be consulted and informed about their rights, severance, and UIF claims. That written notice is extremely important. You have to get that written notice right, because that sets out the layout, or sets out the first step in terms of this retrenchment process or this restructuring process. Okay. You need to inform them and give them the opportunity to ask questions, and give them the opportunity to say, this is the alternative that they would like to provide, and management should consider all alternatives provided. We're not saying that management should accept every alternative provided, because we cannot do that. However, we should have a justifiable reason as to why the alternative doesn't work, if we cannot find it feasible or if it's not viable. Okay. The next thing is to avoid paying severance pay where required. So remember, severance pay is a legal requirement if someone has been retrenched. Okay, you have to give them 1 week of severance pay, so 1 week of remuneration for every completed year of service. So remember, completed year of service meaning if you started, for example, in September last year and you're getting retrenched in June this year, you would not get severance pay because you have not completed 12 months of service. Okay. Now, when we look at severance pay for those that are entitled to it, if we give you an alternative role, so if we are providing you with a suitable alternative role, so remember, it has to be suitable, okay? And we're saying this matches your skill set, maybe it's the same salary, whatever the case may be, it's a suitable alternative role. And you as an employee decide that you don't want it, you refuse it, and you'd rather go through the retrenchment, then we can not pay you severance pay. Okay, so when an employee refuses an alternative role, then severance pay falls away. Okay, but we just need to be very careful that it is a suitable alternative position that we are allowing or we are offering to this employee. In all other cases, severance pay must be paid to the employees. All right. Failing, consider redeployment. So if an alternative role exists, the employees that you currently have, the skill set that fit this, you need to offer them those roles. All right. You cannot decide. You need to make it fair. Remember, the whole point of this is fairness and transparency. You need to ensure that you're being fair to all of the affected employees. If they have the skill set, the qualifications that is needed for that position or for that alternative position, they should be offered the position. Okay. So when we look at practical considerations, all right, so remember there's certain things that we need to remember, okay? Legal compliance is essential to avoid costly disputes and reputational damages, all right? The employers must maintain open and transparent communication throughout the retrenchment process. This includes informing the employees of all reasons of retrenchment or for retrenchment. Remember, it must be economic challenges, technological changes, whatever the reason that you are considering restructuring or rationalizing the organization, we need to inform the employees in that written notice and during the consultative process. These are the reasons that the company is undergoing restructuring or rationalization. Okay. This includes informing the employees of the reasons, the steps being taken. Okay, remember, is there any alternatives as the employer that we thought of, their rights and their entitlements? Okay, all decisions and consultations should be thoroughly documented to ensure legal compliance and to provide a clear record in case of disputes. Okay, this is vital one in any HR process, is that we must have documentation in terms of any consultative meetings, especially the written notice in terms of section 189 that we need to ensure that we are issuing to employees or affected employees. When in doubt, employers should consult HR specialists or legal practitioners to ensure that the process is being conducted correctly. So as much as today we provided guidelines as to you need to consult, you need to do the written notice, these are the payments that an employee is entitled to. Every situation is different. Every organization is different. And the circumstances that has led the organization to the point where they are considering restructuring, rationalization, or retrenchment is different. Okay, so there's certain things that may affect your process. So it is vital that you always consult with an HR specialist or legal specialist when you are deciding or when you are taking the step to undergo restructuring, rationalization, or retrenchment. Right. Lastly, providing resources and support to employees during transitions can help ease the impact and maintain morale. So if it is possible to provide employee support in terms of counseling, in terms of emotional support to the employee, if it's feasible for the organization, then we can try our best to assist. All right. The other ways we support is if we are proceeding with this process and there are individuals that have been retrenched, we provide them with their reference letters. We can assist by maybe contacting different companies that we do work with to see if there's any job opportunities available for them. But remember, these are all if it is feasible. Okay. Lastly is the UIF documentation. So this is a legal requirement. You have to provide upon any termination, a UI-19 and a certificate of service. The UI-19 and a salary schedule will help your employees go and claim UIF for this retrenchment. So they will get unemployment benefits in terms of this retrenchment. Okay, so remember, like I said, legal compliance is essential to avoid costly disputes and reputational damage. Fair treatment of employees is not only a legal requirement, but also an ethical obligation for all employers. Adhering to the structured steps outlined in Section 189 ensures that retrenchments are conducted properly and respectfully. Employers and HR professionals must remain vigilant and proactive through the process to ensure that all legal, procedural requirements are met. Okay, so we have come to the end. I do note that I may be a little bit over time. So before I get to the questions, I just want to say thank you for your attention today and participation in today's session. I hope this presentation has provided you with valuable insights into the retrenchment process. Please feel free to reach out to HR Talk if you have any questions or if you require any assistance with managing retrenchments or navigating any other aspects of the labor law. So HR Talk offers a range of services, as you can see from the last slide. So we're here, and please feel free to reach out to us for any information. Lastly, I just want to say, if you guys want to do the assessment, we do have an online assessment for this webinar where you get a certificate of completion at the end. If you would like to proceed with that assessment, please send an email to training@hrtop.co.za and we can assist you with navigating that. I'm just going to go to the chat. Okay, so there is a few questions. Okay, so what is the acceptable as the consultation period for small scale retrenchment? Okay, so we would look at how much time. So I think the question means is what is the time frame in terms of a small scale retrenchment? I'm going to assume a small scale retrenchment. We're looking at maybe 5 affected employees or maybe 10 affected employees. My suggestion would be so there is a reasonable time frame. I would give it approximately maybe 3 days in between consultations so that they can go in and identify alternative positions or alternative solutions that maybe the employer hasn't thought of, or consult legal practitioners or their lawyers if they need to, or their trade union reps. The next question is, what is the difference between voluntary and involuntary retrenchment, and is there a difference in how UIF claims will be handled? As far as in terms of the UIF claims, there is only one, I think it is there for retrenchment. So that is what the UIF or the termination code would be. In terms of voluntary and involuntary, so voluntary retrenchment is at the beginning of the consultation process, you can offer employees voluntary retrenchment. That usually comes with a little bit of ex gratia payment to say, if you would like to go, now this is what we're giving you, voluntary retrenchments are, we're considering that. And then they take that and they go. Involuntary retrenchment means you go through the entire process, and at the end, they are not choosing. Like I said, retrenchment is a no-fault dismissal. It just happens because of the circumstances that the organization is in, and they will be retrenched at the end. Okay, so voluntary retrenchment. Okay, so the next question is, if there is no union, so when does the CCMA get involved? Okay, that is a really good question. Just give me 1 second and I will respond to that. Okay, so with the CCMA, it depends on the amount of affected employees and the number of employees within the organization. So what I can do, let me just get that. I don't know the numbers off by heart. Like I said, there's different situations and different circumstances. It depends on the number of employees that have been affected and how many employees you have in total in the organization. I will pop it up on this chat after this webinar. All right. Is there any other questions before we end? As the notes and recording of the webinar. The recording will be available. I don't think the notes is made available, but the recording for the webinar will be made available to you guys. All right. Thank you so much, everybody, for joining me today. I think there's one more question. Sorry, guys. Does your severance pay get affected if the employer proposed a position that is outside of the pay scale? Okay, so remember, it has to be a suitable alternative position. So I would look at the drop. So if the salary is way too low compared to what you're currently earning, and that is, remember, it's not considered a suitable alternative. Okay, it has to be a suitable alternative that is very similar to your skill set and what you currently have in order to get your severance pay or to revoke your severance pay. If it is not a suitable, reasonable alternative, all right, then your severance pay would remain. Okay, there was another question. Okay, so guys, we are running a bit out of time. Can you please just pop, if you have any other questions, please pop it in the chat and I will respond in the chat. All right, thanks so much, guys.